hello everyone. While our panelists get settled, I'll go ahead and get us started. In the interest of time, I won't give long opening remarks for this panel. I think that we've been able to really set a great stage, but I will introduce myself briefly. I'm Jelani Jefferson Exum. I'm the Dean and Philip J. McElroy Professor at the University of Detroit Mercy School of Law. I also have the pleasure of being an editorial board member on the Federal Sentencing Reporter Board. So I get to work with Doug and Steve and others, and it's truly fantastic. So I'm really happy to be here. I am the moderator for our second panel, Troubles with the Guideline Substance, Inputs and Outputs. So we've heard already about the history of the road to the guidelines, starting with Judge Frankel's vision and how that may have gone off course a bit. And so with this panel, we get to take a closer look at those actual inputs, what's actually going into the guidelines, and then I think even more importantly, what are the outputs? What's on the back end? What are we accomplishing, if anything, and certainly focusing on some of what we're not accomplishing. So with that, I will turn it on over to our panelists. They will introduce themselves and give a bit of their spiel on what they see as important with the sentencing guideline inputs and outputs. I'm not sure who's starting first, but okay. All right, well then I'll turn things over to you first, David.
Oh, sure. I actually don't have much in the way of prepared remarks because I was thinking, especially in this room, some back and forth and Q&A would be great. First of all, I just want to say I thought that first panel was amazing. Those are certainly some of the brightest lights in this field, and it's fun to hear them talk about this topic. I guess the way we've set up this session, the inputs, I suppose, have to do with the factors that contribute to making the sentences. And there's certainly no shortage of criticism about what those inputs are, and some just well-worn criticisms. This is not a new topic. It seems like every couple of years affords us some anniversary of something having to do with the guidelines, whether it's Frankel or the promulgation of the guidelines. And these are not new criticisms, but I'll tee them up anyway. They really cover a broad range of offenses. You can talk about drug cases where the primary driving factor in drug cases is the quantity of drugs in a case. But like so many of the other criticisms I'm going to talk about, can have relatively little to do with any common sense notion of culpability. You can be a bit player in a conspiracy that involves an enormous amount of drug weight and be facing guidelines ranges that are extraordinary, that don't, by any common sense measure, really equate to culpability. Fraud cases of all manner and variety, and that's a big topic of types of offenses, but largely the inputs have to do with so-called loss amount. Once again, that can have relatively little to do with what any of us would think of as a measure of culpability. Again, you could be a bit player in a fraud scheme that involves an enormous amount of money. You could be somebody who's essentially a fairly legitimate business person who gets off track in one way, shape, or form, or you can just be involved in a scheme that from start to finish is crooked. And that's not measured by loss amount. And we could go on and on about ways in which amount does not equate to culpability, not to mention the way that the guidelines loop in not just actual loss, but intended loss, which can be measured in really crazy ways that, again, don't equate to culpability. You can get to any number of offenses where the enhancements just really pile on, where any individual enhancement you might think, well, yeah, somebody maybe should be sentenced more severely because X happened. But by the time you get done with X, Y, Z, A, B, C, there's been this exponential effect of enhancements that far exceeds what anybody thinks is reasonable. You can look at the child pornography guidelines for examples of this, where the number of images will drive a sentence, the type of images, whether a computer was used, which of course these days is everything. And by the time you get done, somebody is facing just truly extraordinary amounts of time for, again, conduct that, yes, should be punished, but in the extreme way that it's punished relates in small measures to what we would think of as moral culpability. Same in a lot of weapons offenses or drug cases. Beyond just weight measurements, there are all sorts of enhancements that once you start piling them on get really sort of outrageous. And then the last, there are many other problems with inputs, but the last one that I'll highlight would be criminal history category, where, yes, again, I think we can all agree that looking at somebody's criminal history should factor into a sentence. But the way that it's rigidly done under the guidelines and for many types of offenses just thoroughly exponentially raises sentences beyond any reasonable notion of culpability. I'll take gun possession as an example. Somebody who is found to illegally possess a gun, based purely on the conduct, might be facing 1 to 2 years, or they might be facing 8 to 10 years, purely based on their criminal history. I think most people would suggest that that's just far too much severity to hang on criminal history, especially once you start examining what counts and what doesn't when we get into the details of criminal history. So those are some big picture. Obviously, as others have mentioned, the guidelines are extraordinarily complex and we could go through all sorts of inputs, but as categories, those are some that I would highlight as particularly problematic.
Wonderful. Thank you very much. Turn to Doug next.
Thank you, David, and I'm so grateful to be here and get a chance to be a panelist when I'll be moderating for panels to come, in part because this is an issue, and David presented it beautifully, I think largely reflecting his practitioner experience with all the ugliness he sees on the inputs and then ultimately the outputs in terms of recommended sentences in the federal system. But for me, and maybe this is the ivory tower perspective I bring to it, I think there's a really deep, challenging issue that Marvin Frankel really couldn't struggle with as he was calling for bringing law to sentencing, because there wasn't the experience that we've now had for 50 years, which comes with the discovery that some things lend themselves to sentencing law and some things don't. And the things that tend to lend themselves to sentencing law are the things that drive sentences up and up and up and map sentences onto an output that's scalable in terms of prison terms. And I actually give Michael Tonry credit for sort of illuminating this to me in the context of writing about alternative sentences. It's very hard to come up with outputs in community service. Like you could try to scale it. You have to do this much community service versus that much community service. Or in terms of a range of other alternative sentences, it just doesn't fit law quite the same way. And I want to actually beat up my own point. It could, if we had had decades to try to work law out better for other kinds of outputs. But we haven't. We've focused on the output of incarceration, lots of political and social reasons why that has become the primary output for all of our sentencing systems, at least all of our felony sentencing systems. Folks who study misdemeanors would have a richer account of there's a lot more going on. Of course, they would also say there's even less law over there, and that's why it looks that way. But I especially want to focus on the input part just for a minute or two, and then hope to open up a discussion about these topics after hearing the other panelists as well. Just look at what goes into offense factors in the federal system, even in state systems. They're not things related to mens rea. That's actually an ongoing project I'm eager to be continuing to work on. We don't ask, what were you thinking about when you were picking up that package that had that amount of drugs, or downloading those pictures, or involved in that loss amount, or to the extent that we focus on mens rea, it's an either or. Either you had this much loss or you meant to have this much loss. Either way, we're going to punish you extremely based on this quantifiable metric that has kind of emerged because the folks who are focused on building out that law, this was Professor Altshuler's point to some degree before, were a bunch of prosecutors who want the law to function a certain way, knowing that they have the discretion not to leverage that law when it serves their sets of interests. But also even look at personal background. Well, personal background is not in the guidelines. Well, actually it is. It's called criminal history, right? And we've quantified that in a way. Praise be to the new commission that's trying to provide not having criminal history as a way to get a lower sentence rather than historically the way it's been done in the federal system for decades, the way it's mostly done in other systems as well, which is not having criminal history just means you get treated as harshly as everybody else, and then the more criminal history you have, the more harshly that you're treated. Obviously, we're not all a product of our criminal history, and as I think we've become particularly attuned to, and this may be getting to the outputs point, I know Dean Jefferson Exum has written on this as well. Criminal history, it's quantifiable, but who gets both to quantify it and give people that history is a product of a bunch of social forces that we can't easily peel away when we're looking at criminal history. Were you from a community that was highly policed? Looking at Judge Gertner, who I know tried hard to bring that to bear in some of her early sentencing, and the circuit said, no, you don't get to do that. And I don't think it was completely a misguided, sort of shout down. It was a fear that doesn't lend itself to the kind of law that we are doing here. And again, there's lots that can be said throughout the day. We'll talk some more about how much this may be a function of who gets to make the law than the limits of law itself. But I especially think as we think about not only Frankel's contributions, but where sentencing can be going for the next 50 years, a bunch of lawyers have to be somewhat humbled about the reality that law may tilt us in a particular direction, both in terms of inputs and outputs. And without a kind of a very healthy appreciation for the way law itself is functioning in this space, I think it's going to be harder and harder to move us to better places without being open to the possibility that we may need to leave things to be at least lawless in certain pockets, or at least less lawed. Maybe we need a vernacular for kind of explaining this. It's not discretion is bad and law is good. They both have a function to play. We recognize that. Frankel obviously recognized that. But understanding that the solution to bad law is not always better law, it might be less law, is one of the things that I think we ought to be reflecting on after a half century of playing with these tools. Thank you.
Thank you, Doug. And we'll turn to our third panelist, Judge Willis.
Well, thank you. It's always difficult to be the last person because the people who go before you take the things you were going to say. I'm like, oh, that's an excellent point David made, and obviously I can't say that now. So I suppose what I want to say, and while I am a federal judge, I'm a very new federal judge, and as a magistrate judge, it means I am not doing sentencing in felony cases. So my experience in this area comes primarily from being a federal defender and a state defender before that, and then from my time on the bench, seeing what factors judges look at, what things anchor judges, and I think that's really what, to me, is a crucial thing to appreciate about the guidelines. Obviously, it's no longer they're no longer mandatory, but they are very much anchoring. So one of the panelists on the last panel talked about the fact that some 60% or so of sentences are below guidelines. I think Southern District sort of typifies that. It is, typically the guidelines will be the top in the Southern District, and most judges will look at that as the ceiling and sentence below. But it still has a very powerful effect because it anchors the conversation. The lower the guidelines start off, the lower the sentence you can ultimately get. If the guidelines are disproportionately and ridiculously high, that is going to drag up where the judge is starting to think about the case. So it's still very, very crucial and important that we think about what goes into the guidelines and are they fair. David's obviously highlighted several places where the factors that we use to calculate the guidelines sort of don't make any sense and are really disconnected from I think, the purpose of punishment. If we look at 3553A, I think it has a good list of factors to consider. Thinking about a person's history, thinking about the actual history, which is beyond just the criminal history, right? That's where their personal narrative, their personal history comes into play, but also thinking about deterrence, thinking about rehabilitation. None of those things are baked into the guidelines. And so while the judge obviously has to look at 3553A, you have this other factor that you're looking at. What is the guideline range, which doesn't bake in any of those things. And it's one of, I think broadly, the idea that even though 3553 says we should be thinking about sort of a variety of issues, including rehabilitation, as many of the first panelists said, as we said also in this panel, the real focus is on punishment. And that is a problem because you're setting up a system where we're coming up with higher and higher numbers, and it's disconnected from the idea of, is this going to deter the person? Is this going to actually stop crime? Is this going to make communities safer? Instead, we set up this paradigm where we just look at what is their criminal history, what are these arbitrary factors in the crime, and it leads to this number which is always high. And from my perspective, I think one thing that's also important to sort of think about the guidelines is places where bias is sort of baked in, perhaps not deliberately, perhaps unintentionally. Criminal history, I think, is a perfect example of that. One of the panelists was just talking about the fact that we're not really thinking about, when we look at someone's criminal history, what was their community? Are they from a community that was over-policed? Are they from an area where you can easily get arrested for sort of minor misdemeanors that start to rack up? And so that is one place where if we're not careful, we are baking bias and discrimination into the output that we're going to get because it is going into the numbers that are going to be used, particularly to calculate criminal history. So to me, I think you need more flexibility. I think that the guidelines need to be certainly restructured in a way that doesn't, that tries to think about some of the 3553 factors. Are we deterring? How can we rehabilitate? What are things that will actually help a person not reoffend, as opposed to just setting up a structure that is only looking at how can this number sort of be ratcheted up? I think it is interesting that there are so few places in the guidelines where the numbers go down. Obviously, you get the 3 points off for acceptance of responsibility. There's a little bit of a takeaway that you could get for a role reduction if you have a minor role or minimal role, but that's about, and obviously 5K if you're a cooperator, but that's about it. So the presumption is everyone is going to start high, and then based on your criminal history, which could be affected by your community, could be affected by your race, we're going to go higher and higher. And I think that you really need a sort of overhaul of that and a way to make the guidelines reflect what we know from social science, reflect what we know about sort of crime and punishment, and actually have it reflect something that might move towards actual deterrence and actual rehabilitation, which is certainly better for the person being sentenced, but also better for the communities that they'll be returning to.
Thank you very much. Well, we set up today's panel for a brief overview so that we could have a bit of a dialogue. And so I'm going to take kind of moderator's privilege of asking a question, but I encourage those in the audience to please raise your hand. This is meant for us to all get the chance to speak. So one question that I'll ask just starting out is, there's a little bit of preaching to the choir here, perhaps. Everyone on the panel pointed out all of the bad things about the guidelines, things that are going wrong that we're putting in. We're putting in bad ingredients and we're spitting out a terrible tasting dish. And so, so I wanted to sort of put on another hat and ask you before we open it up, is there anything redeemable about the sentencing guidelines? Anything good in there? Anything that we could build positively on, or perhaps even keep it the way it is right now, some bits and pieces, because you see some sort of value there? And anyone can start.
Well, all right. So, I brought sort of race and disparate treatment and bias to my earlier remarks. One of the things that some type of system that does set some metrics and some guideposts can do is potentially remove bias. The problem with implicit bias is that at every place in the criminal justice system where discretion is brought to bear, it's brought to bear to the disadvantage of Black and brown folk. So when you talk about what percentage of Black people are drug users, it's about 13%, which is Black people's percentage of the population. But then you talk about what percentage of arrests for, again, just use for simple possession. And I'm going to get these numbers wrong, but this is roughly what it is. It's about 30 or 35%. And then when you talk about, well, who is getting sort of a slap on the wrist and a shake of the finger from police, but allowed to leave and not be charged versus who is charged, and then who gets some type of a deferment, or who gets some type of mitigation kind of program from prosecutors, and then who actually gets convicted, and then who gets probation versus who gets sentenced to prison. And at every single stage, the percentage of Black folk increases. So that is, if you're left completely to discretion with no sort of guidepost to allow a reality check to let judges know what you're doing to this person may be unfair, and it may be unfair for reasons that you're not aware of, for implicit biases that you have. So having statistics, having data, which obviously the federal system loves its data and loves to sort of have people go back and tell us what percentage of people did this and what percentage of districts did this. But that data, and even personally for judges, in terms of bail, in terms of sentences, we get annually data that will say, here's how many times pretrial recommended release, and you didn't release the person. And then you can have that data provided to you sliced 1,000 different ways, including what percentage of those people were Black, what percentage of those people were brown, what percentage were something else, so that you can sort of have this gut check of, am I uniformly just being lenient, or am I only being lenient to certain populations? So I do think that so it doesn't have to be a guideline system necessarily, because again, it's too rigid, and really what happens is that it's also to the detriment of Black and brown people, because the few places where you can bring lenience in, that's not going to be in their favor. But a system that has no sort of norms and no sort of standards the judge can look at to see, am I truly being even-handed and fair, or is something else animating me, I think would also be a bad one. So it doesn't have to be that we keep a guideline system where judges are being told presumptively, here's the sentence you should give, but some guidance, but maybe not a guideline guidance, or having more data to allow judges to sort of see how they're using their discretion, I still think is very important. And I think that to the extent that the idea behind a guideline system was to take bias out of the process, that's certainly a good instinct. The problem is if you take out too much discretion, now no one is getting proportionate sentences, and everyone is being punished too harshly. So I do think that in an effort to think about how you could reform a guideline system, it is still important to acknowledge that unfettered discretion for certainly hundreds of years in America has always been used to the disadvantage and the detriment of Black and brown folk, and that needs to be thought of if there is going to be sort of reform.
Thank you. David, Doug.
Well, I'll pick up where Judge Willis left off, which is that, I feel like I'm in marriage counseling. So say something nice about the guidelines. So to the extent that I'll say something nice about the guidelines, it is this theory that that there's something good behind Frankel's initial impulse, which is that you do want to have something other than chaos and pure judicial discretion that's not really bounded by anything and leads to all sorts of disparities. The problem is when it comes to discretion, you have to pick your poison. And this really, I think, goes back to what Professor Altshuler was saying, what Judge Lynch was talking about, is the more you constrict it at the back end with judges, the more you are opening up discretion and disparity at the other ends of the process with law enforcement and prosecutors, because they're just going to charge and bargain in ways that account for any sort of mandatory nature at sentencing. I think that, for all practical purposes, since we have this system and it has been set up the way it's been set up, and if you're thinking about ways to tinker, I think there probably are some good examples out there in some state systems of doing guidelines better than the federal system does them. I'm not an expert on those systems, but I certainly hear decent things about Minnesota, other states where there is a lot more play in the joints. They are a lot more advisory. They do act less as an anchor and less as a severe anchor. And so I guess I would encourage continued movement away from their mandatory nature, a real effort to reduce the numbers themselves. And so I suppose there could be a place where you could get where having some framework is not such a bad idea. But to my mind, it would look very different than the framework we currently have in the federal system anyway.
Thank you. Not a bad job saying something nice about the guidelines. Well done, Doug.
Yeah, I'll piggyback off that a little bit. It's sort of saying something, if not nice, at least, an important realism, especially when we're going to drill into the federal system. The federal caseload is especially hard for bringing sensible law to this space, I think, because the bulk of the cases that come into the federal system will be drug cases, but they'll be defined, at least by a prosecutor and a case agent, really serious drug cases in some definition or another, though obviously what that means in Manhattan and in Brooklyn is very, very different than what it may mean in rural Ohio or somewhere else. And so it's both the nationwide scope and then just drug cases in general have, the mules up to the kingpins and everything else in between that create a challenging environment to normalize and understand where that fits in. Same goes for fraud offenses, right? Whether it's, from Bernie Madoff to whoever assisted Bernie Madoff, those are different cases and challenging, even though it's the same ultimate crime that goes on. And then everything from people, stealing gift cards out of mail to, the range of COVID era fraud that now is rightly a focal point for the Justice Department. You're going to have a range of individuals, a range of offenses that are hard to, under any system of law, sort of put it together. And I think to the federal system's credit, it tries. I fear, and this is really where I'm a fan, but think there's so much work that needs to be done, it tries with a lot of rules when I think we'd be much better off with a lot of standards, right? And so this is classic law professor talk, but I'm the law professor on the panel, so I'm in charge of the law professor talk. Just it's the sense I think that was driven. I was glad to hear Dean Weiss talk about the 25% rule. My understanding was the original commission felt like it had to draw up guidelines that were 2 points here, 3 points there, 4 points not. Oh, if you have a lot of criminal history, you should get a higher sentence. If you have a moderate amount of criminal history, you should get a middle sentence. And if you have no or very little criminal history, you should get a low sentence, and let the judges on their own sort of sort their way through over time what's low criminal history, moderate, what's high, especially because this gets to the point about, over-policed communities. What's moderate criminal history in one community may look very different than moderate criminal history in another community, and judges ought to be able to consider that, knowing, because even federal judges are creatures and characters of their local environments, to let judges have a set of standards that can allow them to bring a certain degree of local wisdom to the application of broad law, I think would function better over time, though would still be at risk of implicit bias and a range of other problems there. But I think at the end of the day, there's a lot to be said for how hard this job is and how understandable, if not commendable, the effort by a series of commissions have been to try to bring more and more sense to that law. But again, I think that commitment to kind of a rule-based system is one that if we can find ways away from, and again, it's this sort of fascinating pendulum swing, right? It hasn't been mentioned yet, but worth recalling that when the original commission put in the original guidelines, half of the federal judiciary declared it unconstitutional because just that jolt from all that discretion to this intricate system was too much to bear. But then when the Supreme Court in Mistretta said, no, this kind of works, always forgotten, I think, that all they said was, this works structurally. We're not saying it works in all of its particulars. And yet the federal judiciary, I think, at times kind of, if not overreacted, at least deferred to the idea that, okay, well, I guess this is all constitutional. We got to apply it exactly on its terms. And we can't say certain things like, this particular rule functions in an unconstitutional way, and so we're going to apply a standard here, or this mandatory minimum even is too severe for this kind of case, and therefore, not saying it's always unconstitutional, but for this low-level offender to give 15 years simply because they possessed a firearm and they had this particular criminal history, that's just, it could be Eighth Amendment, it could be a variety of other bases. We didn't end up, again, having, ironically, the constitutional standards, and they are fundamentally always going to be standards in our Constitution, end up informing the application of the law in this space as well. And that's, I think, kind of another kind of interesting failing of inputs, right? That this ends up being just, well, what's the commission going to do this year? And then that becomes gospel. God bless the commission for doing their work. But there's a lot of other law in our system that has gotten kind of left aside, even though, to me, it's so fundamental to the way we see the rest of the system functioning as a dialogue among the branches. And so, I think it's good that we have a dialogue over law, but I think it can be much richer, and one that, again, is less committed to the particulars of rules and more invested in figuring out what are the right standards that can function well here.
Great. Thank you to everyone for your thoughts. So now we have talked about some of the problems, a little bit of promise there. Perhaps you take it how you will, but I see some hands in the audience. Yes. Thank you very much for your comments. We did mention in an earlier panel that, of course, Judge Frankel's initial vision, when we think about a sentencing commission, would have included the voices of the incarcerated and formerly incarcerated. And so I think your point is just there, really highlighting that was an input, that a voice that we don't have. And so I wonder if any of the panelists wanted to address that as a potential input, as affecting outputs. Has that come into your thoughts in informing what's important ultimately in sentencing?
I mean, I'll just say here. Certainly in a lot of areas of policy, we've fortunately, in the past few years, started to take the voices of the formerly incarcerated more seriously. And I think there's a lot to learn there. Front in general, I was taking a look at a Frankel quote that was sort of alluded to earlier, but from the book. In 1973, he said one of his primary reasons for implementing reform was, quote, a firm conviction that we in this country send far too many people to prison for terms that are far too long. Right? That was in 1973. I mean, at a time when incarceration rates, needless to say, were a tiny fraction of what they are now. And so much of what the guidelines have wrought is this sort of power that you're talking about that are in the hands of prosecutors and that tends to move things in the direction of severity.
Thank you. Yes, sir.
To me, when you talk about, I'm going to highlight what you said about collateral consequences. One way that I've always thought about that is that, one, it should be factored in terms of an input as well, because if the idea is that, what is our whole system of punishment about? And 3553, right, the statute speaks to this, the idea that we obviously want to deter people from committing more crime. We want to deter, the broader community by saying, look what happened to Joe. You don't want that to happen to you. You should also not commit crime. And then, the just punishment, right? Punishment fits the crime kind of piece of it. And then obviously there is this idea of rehabilitation. While that's not reflected in the guidelines, it is reflected in the statute. And so to me, when we're talking about what will it take to deter someone, the collateral consequences that they may be facing or may have already faced just from being arrested, just from being charged, and certainly if they are convicted, are things that I think many judges do consider, but I think that broadly this should sort of be enshrined, this idea that what has this already cost you? Because if it has already cost you something collaterally, then the formal punishment that the court is giving can be less, because you have already lost a job. You've already, sort of got the scarlet letter of a felony or whatever it is. So I think that, one, it should really be, and certainly, this is certainly something I've heard defense attorneys argue and many judges do consider, but I think sort of enshrining that as this is a thing we look at as well. And then looking at the sort of rehabilitation piece, right? The road forward. Most people do not receive life sentences, right? They get a term of years, meaning they will be coming back home. They will be reentering their community, and thinking about what that looks like. Certainly the idea of what are the consequences long-term of having a felony conviction, of having done a period of incarceration? And if we want people deterred and rehabilitated, in what ways does society allow them to actually be reabsorbed into society and to sort of function, is certainly kind of beyond our guidelines discussion. But I think it obviously is something that when we think about how should we be structuring punishment, we should be thinking about, right? And this discussion about, are we setting up a system that is focused exclusively on, more time in prison and more of the punishing aspect of it versus the getting to the root cause of why did this crime happen and how can we prevent it from happening again? I think would think more about the kind of things that you're asking about. So I don't know that in a guideline analysis that really is an output necessarily that the guidelines can really do anything about, even if it's sort of restructured. But I do think that in terms of inputs, those are absolutely things that courts should be considering, that this is what's already going to happen to this person by virtue of having this conviction, and therefore we don't need 2 years in prison. We can just do probation because they're already going to have to navigate so much because of the conviction.
Yeah.
Yeah, I'll jump in, Professor Capers, just because it's a spectacularly important question. And just the other day, I was looking at a Sixth Circuit, interestingly, unpublished opinion saying that it believed that collateral consequences were not an appropriate basis for a variance under 3553A, which in some sense undercuts my own. We should have more standards than law, because I think that's the wrong interpretation of the standard, because there's actually a circuit split over that question. And I'm with the judge in thinking it would be nice, whether it be statutory or unclear if the commission could exactly say this, just to encourage a recognition of those factors as relevant to understanding. I certainly think they fit, in my view, of the 3553A factors. But then it gets to the even deeper story, which I think is right to elevate at this moment, which is to even look at outputs only as defined in what the guidelines call for and what happens after, whether we're following the guidelines or going below the guidelines. It's a life-changing reality to be subject to criminal prosecution anywhere, anytime, and to not have that reflected in the way we think and talk about legal reform in this space, I think, kind of undersells. And I do have a quite optimistic view on this front. I think we've seen more consistent bipartisan commitment to doing something about collateral consequences through clean slate laws and a variety of other record clearing efforts, because of an understanding of how it undermines public safety and is, turns, even low level offending into, a lifetime sanction. But again, there's so much work to do there. And oftentimes I think for an awful lot of reformers, advocates and funders and the like, there's, so many directions we need to do work in. How do we get that done? And yet I do think there's at least a greater awareness. But the very fact that I didn't think to bring it into this conversation until your question is a reminder we can keep moving forward.
Thank you. Other questions? Yes.
It's an excellent question, John. I really appreciate it. I do think data goes a long way, right? Where data helps us, and I think commissions, including the federal level, but state commissions as well, have done an extraordinary job of helping to just understand where maybe there's more need for law because we see more disparity or more variance, however you want to define it, in other areas where it's like, we don't have much law there, but everything's sort of rowing in more or less the same direction. That's great. I also think, and this gets even to the idea of, having the formerly incarcerated, other justice impacted individuals a part of the conversation. It's when commissions are out there just listening to, who's getting left behind in the debate over +2, -1, should this go up 5 years or down 4 years? I think there's so much learned wisdom from everyone, right? And again, compliment the newly existing commission for, having a public portal so people can weigh in online and be accessible that kind of way. But I think it's elevating the voices of the range of individuals who necessarily, can't speak to the legislature, aren't going to have the same kind of voice with the Attorney General or the Justice Department or whoever it is that's really making the rules behind the scenes. Commission seeing their role as making sure those voices are well heard and well incorporated into both the data conversation and the policy conversation, I think is an aspect of what I think Frankel had in mind, right? The Dean mentioned it earlier that he, artists, we don't have enough artists on commissions, right? And that would not be a terrible thing, both for the cover of the books, but also the reality that bringing other values to bear, I think, is something that, again, only a politically insulated commission with the time and hopefully the resources necessary to deepen conversations can do, because that's the whole vision of a commission in its own right. And yet I know how overworked and understaffed and challenging it can be when you're getting mandates from the legislature to do this, and then there's a new crime that comes out and somebody cares about that, and so it can be awfully hard to do it. But I think that's where the value is encouraging a breath. And I will say, and this is where I'd love to hear comments from my co-panelists, that going a number of years without a functioning commission, though I know hard on Judge Breyer having to keep the lights on during that time, but I think that kind of usefully reminded all of us the system can function, maybe not function perfectly, there were a lot of problems, but can function without amendments every year. Does that give us some perspective on the kind of deeper reflection we can now do at the 50-year anniversary moment? I don't know. I know you probably like not having commission for a while.
I was just going to say, criticizing the color of the books is real fighting. It's challenging going without the commission in the wake of so much of the First Step Act and significant legislation that I think probably required some addressing. But no, I think we've gotten along fine. And the interesting thing is, probably the biggest ticket item was it's a little bit of a misnomer, but the compassionate release provision, the sentence reduction provision, where certainly here in the Second Circuit, we've had an incredibly broad standard for taking a second look at sentences under that sentence reduction provision. And in other circuits, it's been less generous. The new proposed amendments, I think, are going to help those circuits where it's been narrow and maybe slightly constrain them, although I'm going to certainly argue that it doesn't in the circuits where it's been broad. But I think it's useful to have the commission weighing in on that, given the statutory structure where Congress gave the Sentencing Commission the authority to weigh in on what constitutes extraordinary and compelling circumstances. So that, that's certainly an area where the commission, given the structure we have, it's useful for them to be weighing in. I'll say, first of all, on Booker and on First Step and the second look, I mean, those are enormously beneficial advances, I think. I mean, those have gone a long way towards bringing in more of the standards and more of the flexibility and the humanity to the sentencing process. So those have been extremely important and beneficial steps, I would say. When it comes to, though, the continuing importance of the guidelines, yes, calculating them properly is basically the only thing that's going to be subject to review, with very slight exceptions. But if you look at charts that look at the guidelines range and the actual sentences over time, even though they don't map on top of one each other, they follow one another. So I do think it's still an important conversation in terms of where the guidelines get things right and wrong, because they do exert a pretty powerful influence over the final product in the end. And when it comes to bargaining and client counseling, I will say one of the most challenging aspects is that a lot of times clients who maybe have been involved in the state system, it's so different in the federal system. In the state system, you can, in fact, bargain for a sentence. Whereas here, the bargaining only gets you so far, and there's still a fair amount of uncertainty. It's a hugely consequential part of the process, the bargaining, because it's going to have a big impact potentially on the sentence, but it's not the definitive impact still, because the judge is going to have something to say about it. And so it makes for very challenging decisions and client counseling sessions to say, look, this will help, but I can't tell you precisely how it's going to help if we do X as opposed to Y. So I don't have a great answer for you there, other than it casts a huge shadow, but it's still very challenging to have those discussions and to think through the decision tree because of the uncertainty at the back end.
I mean, I hear you're certainly right that by the guidelines not being mandatory any longer, it allows judges discretion. But as I was saying earlier, and David certainly, I think, highlighted as well, I do think that it has an anchoring effect. So I do think that it is the starting place. You obviously have to calculate them. You're required to, and it's something that will be reviewed on appeal. And that tends to be the place where a judge starts thinking about the sentence. And then we'll look at other factors to say, well, I should be lower because of these things. I should be lower because of this factor about this person's life or this detail that I've learned about, but it is still a starting place. So I do think that it is still an amazingly important part of the sentencing process. In terms of the negotiation piece, I practiced longer in state court than I did federally. I was a state public defender for 14 years and a federal public defender for about 7 or so. And David is certainly right that the way in which negotiation happens in the state level is just qualitatively different because you're actually negotiating for a sentence. And I practiced in Illinois. There were very few. There were some mandatories there, but far less than what you see in the federal system. So you could really have with the prosecutor a discussion about, the person's mitigation and the person's life, the types of things that in the federal system, I won't say exclusively because there is some, there are some times where you have to present a mitigation package to a prosecutor, but mostly those arguments are happening to the judge. Whereas in the state court, you're making those arguments to the prosecutor and, trying to come up with them with a number that makes sense and also one that the defendant can live with. And then when they plea, they know what they're going to get versus the uncertainty in the federal system. But I think the other thing about that negotiation, that this is really less about the guidelines and more about mandatory minimums. But as David pointed out before, when we have those mandatories that are baked into the system, it is taking away the power and the discretion of judges to say, well, based on these facts, I think this is an appropriate sentence, or based on these facts, this is an appropriate sentence. And instead, it's now for the prosecutor to say, well, I'm going to charge, a mandatory 10 years, a B1A for this offense, or a B1B for this offense with a mandatory 5, or no mandatory. And so it puts people, and this, I think, ma'am, comes back to the point you were making earlier, not exactly the same, but so many people who plead guilty because they're being offered a lower range or no mandatory, and the fear that if they go to trial and are convicted on the mandatory sentence, even if they have mitigation, even if they have explanations, the power is taken away from the judge to say, well, you had a trial, but I see why, and I see what the mitigation is, and I'm still going to give a lenient sentence. In a system where there's these mandatories, the judge doesn't have that power. So many people plead in order to get away from a mandatory minimum who might have otherwise fought their cases. So I think that's really the place where those discussions are really crucial and vital, is in the debate with the prosecutor about what the person will be allowed to plead to. And that's an area where the judge, as you say, has no power, because judges don't decide charges. And it's a place where if you didn't have mandatories, if you have more discretion, then the judge would be able to say, this is the appropriate outcome, as opposed to the prosecutor.
Thank you very much. We have time for just about one more question and a quick response if there are any. And if not, I had a comment to make on that, that question of that.
There was one
Oh, we
down.
do have one. Okay. Well, I'll make it very quick, but it's again about sort of this post-Booker world of having judges only have to calculate the guidelines and then sort of being free. And panelists have already discussed that anchoring effect. But I just wanted to note that this really just shifts the input and output discussion away from the guidelines into the judge after that anchoring effect, because what we're left with then is this world in which it used to be that the guidelines gave information, whether it was accurate information or not, but judges were receiving that information to say, okay, this is what makes a good sentence. And so for me, I see a big gap in what communication we give to judges, not about the defendant or about the offense, but that information about, well, how does the judge get to the outcome that he or she is hoping for in a case as far as the purposes of punishment? What actually informs what makes a sentence one that is a productive sentence, or one that reduces recidivism, or one that doesn't have these large collateral consequences, or takes into consideration those consequences? To me, that's a big place where we're now missing a conversation about inputs, and therefore having sort of faulty outputs again.
Well,
and so,
that's a perfect segment to one of our breakout panels
Okay,
that I know
great.
you're speaking at that I'm moderating. So I just want to be the cruise ship director for now and say thank you all for the folks on this panel. Join me in thanking them.